All right, is that everyone that we're anticipating as far as council know?
Yes, Your Honor.
All right, then the court will call cause number CV335-21DC. This is in the interest of Brittany Fornes, and the court had previously issued what thought was a final order in this case. It was told by the Court of Appeals that it was in fact not final because of certain procedural aspects. And so once they sent the case back, I believe there were some provisions under the Texas Family Code that remained unfinished, for lack of a better term. And so I suppose that's where we will go at this point. And Ms. Crane, is that your understanding of where we are today?
That is my understanding. And we also just have one additional piece of evidence to present to the court today.
All right. And Ms. Lannon, I know you weren't part of the earlier issue, but is that your understanding as well, having gotten up to speed on it?
It is, Your Honor. I will say that I think at the very beginning you might have said my name instead of Miss Fornes' name as part of
I may have. I meant Miss Fornes, yes, and I meant Brittany Fornes, yes.
And so, and we do have some discussion regarding the new evidence that was she's trying to present.
All right. Then my understanding, Ms. Crane, if I remember, you are the movement, and so you may proceed, and then I'll take whatever objections, things of that nature there are.
Yeah, do you want me to do a kind of reminder opening statement, or you feel like you're good?
It wouldn't hurt to give me a brief summation. It's been a while.
Okay. So, Your Honor, in regards to this fact, my client filed an adult paternity suit to adjudicate parentage. There is a presumed father in the case. His name was Tommy Hagar. There was testimony at the previous hearing that he separated from Karen, who is Tiffany's biological mother, in July of 1981. Tiffany but they did not divorce until later in the year, within that 301-day period that's prescribed for presumed fathers. Tommy Hagar is the father according to the birth certificate. He testified that he had had no contact with Karen, the biological mother, since July of 1981, and they had not had any sexual relations since then. That she was seeing Monty Pichelle, the respondent in this particular cause number at the time, and that he was Tiffany's biological father. Tiffany was born on June 22nd of 1982. So in the prior hearing, the court did make findings that that basically we met our burden to show that Tommy and Karen did not live together or engage in sexual intercourse with each other during the probable time of conception. And we are also just asking the court at this time to order genetic testing. And then the law also says that an adult child is a child is the only person in the circumstance that these facts present that can request genetic testing and adjudication of a father, and that's exactly what's happened here. Mrs. Forms is requesting genetic testing of Monty Puchel. We would ask that take place at the Hill County Medical Center here within the next few weeks, and my client will pay for that testing. So, and if the court is denying genetic testing, we would ask that Tommy Hagar be adjudicated the father, and I would remind the court that Mrs. Forns, my client, Tiffany Forns, and Tommy Hagar have only ever had contact when she requested he do DNA testing for this case, that he was not an active father in her life, and that it would in no way affect her pursuant to the ability to deny the genetic testing. It's not going to affect Tiffany if he is named as the father, because it's not somebody that she even knew. So, and so that's what we're requesting, is the genetic testing of Monty Puchel.
All right, Ms. Lynn.
Your Honor, I know that there is a motion to reconsider the genetic testing related to Monty Puchel. However, I think the Court of Appeals was pretty clear that we needed to bring it back here, correct the order so that it complied with the statutory requirements, and proceed from there. Additionally, I don't believe that we have the ability to reconsider the genetic testing and include in that consideration, if we were to, the Exhibit A as proposed by Petitioner, because that was based upon a quote, agreed order, but it was only agreed to by two of the parties in this case. It has to be agreed to by everybody. And should we have been notified of that motion for genetic testing in November, I think it was November of 23, then we would have requested a hearing on that motion to discuss whether there should have been genetic testing of Tommy Hagar to determine the parentage. And we would have objected to that testing, and for a litany of reasons. So without having a hearing and having an order that's agreed to by only a portion of the active live parties in this case, then I don't believe that we can consider that DNA result until a proper hearing is conducted. Certainly, if we are acting on the Court of Appeals' instructions, we need to correct our order and then proceed from there. And in this case, Petitioner pled for genetic testing, and they pled for adjudication of parentage relating to Tiffany Forns and Monty Puchel. They did not ask for adjudication of anything regarding Tommy Hagar. This court denied the genetic testing of Monty Puchel, and then the statute says what the court has to do. If you're going to deny the genetic testing of Monty Puchel, the court has to adjudicate Tommy Hagar as the father. So I think in correcting that order, we simply have to adjudicate Tommy Hagar as the father and proceed from that point.
All right, I think I'm following that. All right, then, Ms. Crane, you may proceed.
Your Honor, we would offer P1, which I previously provided to the court reporter when I came in this afternoon during the prior hearing, which is the genetic testing of Tommy Hagar and also Tiffany Forns, showing that he is not the biological father of Tiffany Forns. We would offer that as P1.
And Your Honor, obviously, I would object to that being admitted, because I don't believe that it can be considered by the court, because that order was not part of a hearing that was conducted based on everybody, and we would have objected to that order in the first place. As far as authenticity, though, I certainly don't object to that.
All right. Well, as far as the authenticity part of it, the court will admit it, I suppose. I understand your opening, Ms. Landon, that we haven't jumped kind of through the cookie cutter provisions, I think is what I understood to be said. So I will admit it as far as find it is authentic, and then I guess we'll go from there. Let's figure out, because the last thing I want to do is have a case before the Court of Appeals 2 or 3 times. So, what else, Miss Crane?
Your Honor, that is the only evidence that we wanted to offer, and of course we want to offer it for all purposes. I believe that I'll have to look back and see filed.
I don't recall the sequence of events that were occurring when that test was done. Miss Landon, do you remember whether you had already come into the case at that point, or was that before you came in?
I had not come into the case. The cross-claim to include Mr. Hager was filed in October of 23, and it doesn't look like it does ask in that cross-claim for genetic testing. That obviously was after the appellate issue, so it was not part of the appellate record or anything like that.
Yes,
in November, it looks like there was just an order. There was no specific notice of hearing or a motion or anything like that. It was just based on the original pleadings in October. And so that agreed order was entered in November 22nd of 23. And I say, again, agreed order by two parties.
It's to the cross claimant and the, yes.
Yes.
Okay. And I don't honestly know what effect that has. I certainly understand the argument. Okay. All right. Then I guess I'll let both sides then argue their positions on that. If there's anything over and above what I've already been told.
Your Honor, I mean, as far as her or Monty Pichelle, another party's ability to request genetic testing. I mean, we did file a counter petition requesting the genetic testing. There was an order filed. There has been no challenge of that until today in regards to whether or not he should be tested. I don't really know what grounds he has to object to the genetic testing. We have already established that Tommy Hagar was not this presumed father. He could have, honestly, Tommy Hagar could have tested outside of the court, and we could have offered that today as evidence under the business records affidavit that it was it's evidence that should be considered in this case that Tommy Hagar is not the biological father and that he should not be adjudicated as such. Our argument remains the same as it has this entire time. I don't believe it's necessary to have all the parties to consent to a motion for genetic testing. I think that the parties that are being genetically tested can agree to that. So, I mean, our same arguments would apply to the motion to object to the genetic testing of Tommy Hagar and Tiffany Fornes as it does with the case for the genetic testing of Monty Pichelle, Your Honor. I mean, we did ask for that in a pleading. It was granted by the court as to the parties that are affected by the actual genetic testing as evidence to consider in this case. And I believe that the facts remain the same. I mean, this court has already made a finding that there's sufficient evidence that he's not the presumed father, that they didn't have sex during the time period, and that they didn't reside together during that time period, and therefore that he is not the biological father. And now we just have the genetic testing as evidence to back that up. And therefore, I feel that we have met our burden in this case, and we are requesting the genetic testing of Monty Pichelle.
Judge, nobody's saying that they have never filed pleadings that ask for genetic testing of Tommy Hagar. They did. They just filed them after the appellate court issue was presented and had gone up and then come back down. And I think based on the appellate court's ruling, we're at a position where we have to address that first. Then we could have gone forward and had a hearing on whether or not genetic testing of Tommy Hagar needed to take place. And just like anything, all parties, I mean, we have plenty of cases that are custody priority cases that are not child support related cases. We still have to serve the AG. Just because they don't believe that another party is going to have a dog in that fight doesn't mean that that other party doesn't get served and asked whether they do. And we would, in that case, have had an objection. I think there are a litany of the factors regarding best interests that would have weighed in favor of not testing Tommy Hager and being able to deny the testing of Tommy Hager. So we didn't get the opportunity to present those.
But who would have the standing to argue that other than Ms. Fornes, I guess would be my question.
Well, the statute is not specific to, to the presumed father and the child. Yes, it lists presumed father, child, and mother. At minimum, they should have had, if we were going based on the statute and who it identifies, they should have at least had mom signing off as well, but they didn't. But it doesn't say that these...
Mom was previously joined as a party. I remember that.
And she should have had to sign off on that order as well, since if we're going on who's labeled in the statute. Right. But factors there do not limit the impact of those factors on purely those people identified in the statute for testing purposes. Other parties can object to that testing. Number one, the court may deny testing if two of those specific items are met. The conduct of the mother or the presumed father stops that party from denying parentage, and it would be inequitable to disprove the father-child relationship between the child and the presumed father. It doesn't say that it would be inequitable for only the child or the presumed father. It says it would be inequitable. In this case, it would be inequitable for other parties involved, including my client in particular. But that is an argument that we didn't get an opportunity to make. And therefore, we don't believe that that order or that those DNA results should be considered right now. In my opinion, we should be going forward with the Court of Appeals instructions and fixing our judgment first, and then proceeding from that procedural point. Otherwise, we're making a mess.
Ms. Crane,
I disagree with that, because I think that what the court said is that this is not a final hearing. We hadn't got to the point of a final hearing, which means you can still offer evidence. The case is still open. I can still ask you to reconsider your prior decision for motion for genetic testing because it hasn't been finalized. That's what the court said. They didn't say you have to adjudicate Tommy Hagar as the father. They said this is not final. And maybe this is why it's not. And until you make a decision about that, it's not final. Well, we have new evidence to present to aid you in your decision as to whether or not Tommy Hagar should be adjudicated father. And I think it is feasible in this case.
We're not hearing you, Ms. Crane. I'm not sure what happened.
It just got
Yeah, it just got garbled. I don't know.
Okay. Where? At the beginning? You want me to
yeah, pretty close to the beginning.
Okay, so what I said was basically the Court of Appeals did not say that we have to adjudicate Tommy Hagar as the father. They said it is not final because there was no adjudication of paternity, and therefore it was not an appealable issue. That's why they kicked it back, which means that the case is still open, and the petitioner can still present evidence. The petitioner can still make a motion or have genetic testing. In this case, we added a party, we interpleaded a party, and you couldn't adjudicate the paternity of Tommy Hagar if we hadn't added him as a party. So we did go back and do that. And as far as the authority to deny the genetic testing, I've said this over and over again. When you read through that statute, when you read through the annotations underlying that statute, it's not what the estoppel provision is for, hey, this guy has served as Tiffany's dad for her whole life. This is the only father that she knows. We're not going to go back behind that and take that father from her. But that's what this whole statute addresses, and all of these factors, that's what they all go toward. And that is not the situation here. This is a man that Tiffany doesn't know at all. Maybe could identify on the street because she's now met him twice for the purpose of genetic testing. And so you are not harming Tiffany by ordering or denying an order for genetic testing of Tommy Hagar. I guess Monty can argue that he's hurt because now we're sure that Tommy's not the dad and that you're going to have to really adjudicate somebody as the father that's for sure not Tiffany's dad in any form or fashion. And so, I mean, for the purposes of this hearing, I feel like I said, the court pushed it back down because it wasn't finalized and they didn't have the authority to hear it at that point, which means it's still an open hearing, which means we can bring further issues before the court. And that's exactly what we've done in this case. And we are asking for the motion to genetically test Mr. Pichelle.
Your Honor, if I can, just briefly.
Sure. No, go ahead.
The court didn't say you have to adjudicate Tommy Hager as the dad. That's true. The court said that the order was not finalized and it needed an adjudication. The statute knows that that is coming. So if you're going to deny genetic testing, it says you must adjudicate the presumed father as the father so that there is finality. So we don't still have this problem of a presumed father sitting out there somewhere. Right. So the statute identifies that, not the court. And once we fix that in our order, along with a couple of other little procedural pieces that the court identified, then we're done. Now, as far as, while I don't think we need to be arguing the merits of whether there should be genetic testing at this point, because I don't believe that we're there, I understand Ms. Crane's argument. And we think about these kids who have a great relationship with a father, and then we rip them away, and we don't want that happening. But the reality is, and I have to tell my clients this all the time, as long as you're not an abusive or a neglectful parent, you can be a crap parent. He chose to be a crap, non-existent parent. He knew he was a parent a couple of years in, and he chose not to be a great one. Unfortunately, that's the hand that she was dealt. That doesn't mean that we go through and we rip apart other families as well and restructure other families as well just to appease that situation because she got dealt a bad hand.
Well, I want to go back and read the file and the Court of Appeals opinion very carefully again, and would like to get some form of order that is final and appealable, which I will assure everyone the next time I sign an order, it'll have those words at the end. But I will do so, and we'll try to let you all know where I think we need to go from here. I was very hopeful when all this came back that the Jerry Jones case was going to give us some direction, and that gave us no direction whatsoever. But that was because of a non-disclosure agreement that apparently got violated that didn't know anything about. So I don't have that to deal with. So I appreciate y'all's time, and I will dig in the file this afternoon, try to let you know something in the next